Again, my name is Matthew Meyer. I am the Minnesota Ombudsman Director for the Department of Defense Employer Supported Guard and Reserve, and I'm going to be discussing today the employment leave laws for service members and their families under USERRA and the FMLA. I'm going to talk about three general areas today. First is going to be ESGR, the Employer Supported Guard and Reserve, who we are, the resources that we provide, not just to employers, but also to reserve component service members and their families. And then I am going to discuss the federal law that requires reemployment of our reserve component service members and active duty service members, actually, and some of the provisions that it requires. It is a fairly broad law. I will not be able to cover it in detail, but hopefully I will alert you to some issues under it. So if you do have some follow-up questions, if you are an employer and you have questions about whether you're in compliance or not, you can reach out to us, to me individually, to ESGR, or to your individual counsel to make sure that you have a good understanding of USERRA. And then finally, I'm going to cover some parts of the FMLA, the military leave provisions under the Family Medical Leave Act. They are very helpful in understanding, especially if you are a reserve component service member or employer reserve component service member. It's a little bit outside of the area that ESGR traditionally presents on, but it is helpful to understand some of these provisions if you are an employer. So let's jump into ESGR. Employer Supported Guard and Reserve. It was formed in 1972 and was formed in order to gain and maintain employer support of the Guard and Reserve service members. It is part of the Department of Defense Reserve Affairs. It is staffed primarily by volunteers. There are about 3,600 to 4,000 volunteers across the nation and overseas possessions, and we are considered volunteer employees of the Department of Defense. We are considered the principal advocate for employers within the Department of Defense, and therefore we have a number of resources that are available or a channel of communications to those employers who have concerns about their obligations under USERRA or the Department of Defense and the way that they handle the reserve components of the national defense. One thing to keep in mind in terms of the reserve components, since 9/11, almost half of the uniformed military is in the reserve components. That's the reserves of the various active duty components, as well as the air and National Guard components. It fluctuates between the low 40% to about 48% since 9/11. And therefore, it's critical in understanding the obligations of employers of this important part of our national defense. And conversely, the Department of Defense takes seriously the concerns of the employers of the reserve components because they are an integral part of our national defense, because they provide that support to our reserve component service members. So in order to accomplish our mission, we have three primary functions that we perform. The first is to recognize outstanding support of employers. Therefore, we have a system of awards. We have the Patriotic Employer Award. If you're a service member and want to recognize your supportive employer, you can nominate them for an award. We also have a system of state awards. And then finally, the Secretary of Defense annually gives out a few Freedom Awards to the outstanding employers in the small employer, large employer, and public employer categories. Secondly, we increase awareness of USERRA. For instance, me appearing here today presenting to employers, I give a similar presentation to service members. We try to educate both employers and service members about their rights and obligations under USERRA in order to avoid any kind of misunderstanding. We also have a system of statements of support where employers can express their understanding and willingness to abide by USERRA in a statement of support that they can sign and then hang in a prominent place to show the public that they are supportive. And then finally, what I am primarily focused on is the Ombudsman services. I've been an Ombudsman for the last 13 years, and essentially we try to resolve conflicts. We provide informal mediation. We do not represent either the employer or the service member. We simply try to correct any misunderstandings or miscommunications and patch up that relationship. The Ombudsman services is a neutral service, and we're required to be so by statute under the Administrative Dispute Resolution Act, which governs our neutral status as a mediator. I do want to direct you to the ESGR.mil website. We have a lot of great resources there for employers as well as service members and volunteers. The tab that's indicated here on this slide shows the employer resources that are available. By the way, we have many of those resources downloadable in our exhibit booth here today, so please visit us and download whatever you want, as well as a copy of this presentation, which is a good resource. If you want to download a PDF of this, it does have links to some of the resources that are cited in there. And then we also have a request assistance function. And essentially, you can either email or call into our office in Northern Virginia, and we have skilled operators who can answer questions about USERRA or related issues. And that service is available to employers as well, and we have lots of employers who will reach out to us and seek guidance on some of these issues. These are some of the resources that are available on our website, as well as downloadable in our exhibit booth. So let's jump into USERRA. USERRA is the Uniform Services Employment Reemployment Rights Act. It was passed in 1994, but its predecessors go back to 1940. And essentially, they all had the same purpose in mind, and that is to encourage non-career uniform service by minimizing disadvantages to civilian careers. And it does this by requiring reemployment and prohibiting discrimination against those who have civilian careers but leave in order to perform uniform service. And since the Supreme Court decision in 1946, it is to be liberally construed to the benefit of those who left private life to serve their country in its hour of great need. And oftentimes when you have an issue that comes up under USERRA and it's uncertain, oftentimes courts will look at that guidance and construe it in a way favorable to the service member. The first question is the service member eligible for protection under USERRA? And there are 5 eligibility requirements that I list here, and I'm going to go through them, and I'm going to raise certain issues that have come up under each of those requirements that relate to the relationship and oftentimes misunderstanding by the employer or service member about those requirements. First is the service member must be absent from a position of employment by reason of uniform service. And there are a couple of issues involved with that requirement. First is, who is an employer? Well, one thing to keep in mind is USERRA is the broadest employment statute, federal employment statute on the books. It covers all employers. If there's one employee, it covers that employer. Size is irrelevant. And it also covers joint employers. Depending on the situation, unions can be considered employers, plan administrators, temp agencies, and the workplace employer can be considered joint employers as well. So it is a very broad statute. It covers successors and interest. The only exceptions to this requirement is essentially Congress, Native American tribes, and in certain circumstances, clergy. But it's a very minor exceptions in terms of total employees that are affected. What is employment? Well, the employment is any type of full-time, part-time, or seasonal employment. The only exception is if the employment is, quote, brief, non-recurrent, end quote. And it's the employer's burden to show that, and it does not come up very frequently, although it does occasionally. So the next concept is absent for the reason of uniform service. And of course, uniform service includes service in the active duty and reserve components. It also covers other organizations, such as the National Health Service, the National Urban Search and Rescue System. So it's not just the military branches and the Coast Guard of the uniformed services. It goes beyond that. Uniform service also covers both voluntary and involuntary service. This is an issue that oftentimes employers will try to distinguish, but there is no distinction, and it does not matter if the service is involuntary or not. It also covers civilians. An employee who leaves for examination for initial enlistment, basically a civilian who decides to join the military, but for one reason or another is unable to, and may have to come back and be reemployed in the position that they thought they were leaving once they're denied entry into the armed services. USERRA also protects them. The exclusions under USERRA is when a National Guard or Air National Guard service member is called up for state duty. However, be careful, Minnesota, as does many other states, extend USERRA protections by state law to cover those National Guard members who are called up for state duty, even if the duty is in another state. Next requirement is prior notice. So when the service member leaves for uniform service, they have to provide prior notice to the employer. They just can't leave. And it can be written or verbal. It can be immediately prior to the next shift, although the Department of Defense asks that the service members provide as much notice as possible, preferably 30 days, and in writing. That guidance only applies to service members and does not affect their reemployment rights. Under USERRA, the notice can be verbal, it can be immediately prior to the next shift, and it will be effective. The only thing that is required is that it indicate that the service member is leaving for purposes of uniform service. And of course, there are exceptions in cases of impossibility or it's unreasonable or military necessity, that prior notice can't be provided. One thing to keep in mind, the notice can be even in the form of an explicit resignation. The service member or the employee can say, I'm not returning to work. And it will still be effective as long as the service member says, I'm leaving for uniform service. In other words, there can be no waiver of USERRA rights in a resignation form or like form. The service member can always change their mind and seek reemployment. This is the point where I usually want to highlight the fact that the Department of Defense has regulations and instructions that are published that are designed to assist employers. One of those is the ability for employers to reach out to the service member's command in order to try to have the orders modified or adjusted somehow. And this is usually when there is some sort of undue hardship or financial burden, operational burden of the employer. And the perfect example that I use to illustrate this is when a service member may be a tax preparer or accountant, and they're called to maybe their monthly drill or annual training right in the middle of tax season. And it can be a financial or operational hardship for the employer. The employer can reach out to the command and pursuant to these regulations and the instructions, seek to have the command adjust those orders to alleviate the undue hardship. Also, the regulations and guidelines also has units appoint somebody specifically to be a liaison with local employers in terms of these types of requests, or requests for information in terms of type of discharge, the dates of military service, so on and so forth. So the Department of Defense is trying to alleviate some of the hardship imposed by USERRA, but employers have no rights if they're turned down or they don't think that their issues are properly remedied. USERRA still governs the reemployment rates. So the next requirement is subject to a lot of confusion by employers, and that is that once a service member exceeds 5 years of non-exempt service, they will no longer have USERRA rights. But oftentimes employers misunderstand this just without considering the exemptions to it. But the fact is, first of all, the 5 years applies per employer. So if the employee changes employers, the clock is reset, in other words. And then, of course, the main thing is there's so many exemptions. And since 9/11, many of the deployments have been exempt because they're either involuntary, they involve contingency operations, or regular training is exempt, or orders are specifically exempt by the service chiefs. And so it is not unusual for service members to serve 9-10 years and still not reach that 5-year threshold because most of their service is exempt. Again, ESGR can assist in verifying whether a service member has exceeded the 5-year limit for employers. So employers can contact us and we can assist in determining whether that limit has been met. And then the next requirement is that service members must serve under honorable conditions, or in other words, that the service must be qualified, or the discharge from service must be honorable. And this is fairly straightforward, although one thing I note oftentimes is if the discharge was the result of PTSD or TBI, traumatic brain injury, or a sexual assault, there are avenues where that discharge can be upgraded later, and that arguably could renew or reapply the reemployment rights of the service member. Again, ESGR can confirm whether a service member has a qualifying discharge or not, and then timely return to work. This is after the service. How long does a service member have in order to return to work? And it really depends on the length of the service. The longer deployments of over 180 days, the service member has 90 days. For 31 to 180 days, it's 14 days. The one thing I want to discuss a little bit more detail are the short uniform service. This is the weekend drill or the annual training, and the service member is expected to return to work promptly after being released from orders. But what happens is the employer wants to schedule the service member, maybe for an early Monday morning shift, when the service member may have been released from orders at midnight or late the previous evening in northern Minnesota. And in those situations, the employer cannot require the service member to work a shift, a regularly scheduled shift, unless it is longer than the amount of time it takes for safe travel and 8 hours of rest. And if that shift starts before then, then the service member cannot be required to work the shift or any part of the shift. They can't be required to come in halfway through a shift. It has to be, that the shift begins after the 8 hours of rest and safe travel time. Now, of course, the service member can always agree to work that shift, notwithstanding USERRA, but they cannot be required to it. And of course, there can be extensions for them to report to work up to 2 years for hospitalization and convalescence. And regardless of when the service member wants to reapply or get back on the schedule, the service or the employer must promptly reemploy them, and that means immediately of its service of less than 30 days, but in no situation longer than 2 weeks. Even if there's a qualification issue, the service member must be reemployed. If there is some certification, retraining, or whatever that's required, they have to be put into some sort of position until they're qualified for what's called the escalator position. One last thing I want to bring up, the Department of Labor has determined that the release of a service member prior to uniform service must comply to the similar requirements. In other words, the service member must be given 8 hours of rest and safe travel time to report to their uniform service after their shift. So they can't be scheduled for a late Friday night shift and be expected to report first thing Saturday morning. I'm going to go through what the obligations are. The main thing is prompt reinstatement, reemployment, hence the name of USERRA. And then the second part is anti-discrimination and prohibition against retaliation. And one thing to keep in mind is USERRA is the floor. In other words, the employers, state and local governments can always offer more, but they cannot offer less than what is required by USERRA. And also, the service member must be afforded the most favorable leave of absence policy that is provided by the employer for any similar type of leave of absence. This often comes into play when there is, for instance, a paid leave of absence for jury duty, but not for short-term military duty. That would not be consistent with USERRA. The employer must provide service members the most favorable leave of absence policy. So reemployment, that's the main focus of USERRA. The service member comes back from an unpaid leave of absence, and he must be reemployed at a position he would have held had he remained continuously employed. Hence the metaphor of the escalator. The escalator goes up, the service member gets off to perform uniform service, and then gets back on at the same step on the escalator, and which would be higher, and is entitled to all the pay, seniority, and status that they would have attained had they remained continuously employed. The thing to keep in mind is when you're talking about seniority-based benefits, everything would be retroactive. As if the service member was employed during that period. What is affected? Well, primarily promotions or promotion opportunities. The service member must be given the promotions they would have had if it was seniority based, or allowed to take promotion exams in order to determine whether they would have been promoted during their absence. And if they pass, then that promotion must be retroactive for all pay, seniority, and status. Apprenticeships and probationary programs, they must go back into the program if it's a bona fide program, but once they complete it, then all their seniority is retroactive to when they would have satisfactorily passed it had they remained continuously employed. And of course, the escalator may go down. There may be layoffs where the service member would have been terminated regardless of their uniform service, in which case USERRA does not protect them. It only protects their position had they remained continuously employed. Disabilities. If a service member returns with an injury caused or aggravated during military service, they actually have more protections than under the ADA. If they are not qualified for the escalator position, they have to be given a position of like seniority, pay, and status for which they can be qualified. Even if it's occupied by somebody else, they have priority over that position. The person in that position will have to be reassigned or terminated to make room for the returning service member. The temporary disabilities, once the disability is resolved, they have to be returned to the escalator position. One thing to keep in mind when you're dealing with disabilities. Some other issues that come up, bonuses and other compensation. A service member cannot be disqualified from bonuses because they were on uniform service, although bonuses can be prorated to reflect the amount of time that they were actually employed during whatever the bonus period was. Service members are protected from discharge except for cause, depending on their length of service. Documentation. Documentation is a frequent issue that comes up with employers who always like to have documentation. Well, under USERRA, documentation can be required only after the service of more than 30 days. So short-term service, the employer cannot require documentation. Longer service, they cannot withhold reemployment pending documentation, but they can ask for the documentation to verify USERRA eligibility. Vacation days is another issue that comes up frequently. Vacation days are taken solely at the discretion of the service member. The employer cannot dictate whether the service member actually takes vacation days for military service. Benefits. Under health plans, the service member can elect to continue health plans up to 24 months. But after the 30 days, the service member must pay 102% of the premiums. Another issue that comes up is pensions. A returning service member must be allowed the opportunity to make up pension contributions if that's the type of plan, and they have 3 times the length of service up to 5 years to do so, thus triggering the employer's obligations under the pension plan. Next is anti-discrimination. USERRA prohibits discrimination, and discrimination is defined as any adverse employment action that the service member's past, present, or future uniform service was a motivating factor. It doesn't have to be a substantial factor, the sole factor. If it was a motivating factor, then it would be deemed to be discrimination. Now, one thing to keep in mind is the regulations and the courts recognize discrimination is hard to prove with direct evidence. It's oftentimes not available, so they rely on circumstantial evidence, and that type of evidence can be in the form of the proximity and time between an adverse employment action and the notice of an upcoming service, uniform service. It can be expressed hostility in the workplace by coworkers or managers. Frustration at having to adjust the schedule and to accommodate uniform service by a service member who is gone. Oftentimes, well, I shouldn't say oftentimes, but sometimes it can be something expressed like, well, John Smith needs to decide whether he wants to make this job a career or his military a career. Something like that. That would be circumstantial evidence of a discriminatory animus. Retaliation, again, if there is any kind of a complaint or assisting in a complaint by a coworker who may not even be a service member. If there's any kind of retaliation for that conduct, there would be a violation of USERRA. Well, I'm going to skip forward here because I do want to cover the Family Medical Leave Act. And so there are some issues here in terms of enforcement. I'm more than willing to answer any questions you may have about that after the presentation. But I want to go to the Family Medical Leave Act and specifically the 2008 military leave provisions. And there are two of them. They're called qualifying exigency leave and the military caregiver leave provisions. One thing to keep in mind is FMLA is not a broad statute like USERRA. It only applies to certain employees and certain employers. And there are certain requirements to determine whether you are covered. If you're covered by FMLA, you're covered by the military leave provisions as well. The one thing I would say about the qualification issues is if you are a covered employee or are trying to be considered a covered employee, but you're a service member who was gone on uniform service for part of the 12 months in which you needed to work at the employer and to work a total of 1,250 hours. If you didn't reach that threshold because of your uniform service, you would still be a covered employee. You cannot be disqualified because you were performing uniform service and that precluded you from becoming a covered employee. So let's move to the qualifying exigency leave. Basically, you're allowed up to 12 work weeks of unpaid leave for a covered employee per the regular employer 12-month period. And you have a familial relationship with a service member who is performing covered active duty. Now, the covered active duty is different between the regular armed forces and the reserve components. If the service member is in the regular armed services, they only need to be deployed to a foreign country. You may have an employee, their son or daughter is in the armed services, they get orders to Djibouti for however long, and that would be a covered regular armed forces, covered active duty. If you're in the reserve components, however, the deployment must be to a foreign country, but it also has to be for a contingency operation. And that basically excludes, for instance, the local Marine Corps Reserve Unit had a training exercise in Norway about a year or so ago, and that would not be covered active duty. It was to a foreign country, but it was not for a contingency operation. and foreign country includes international waters, but does not include U.S. territories overseas. So I'm going to skip over some of these charts here. They basically explain the familial relationship that is covered or not covered under the different provisions. I do include a link as well as a download of the Department of Labor handout that I got them from. They are available in our exhibit booth, and please feel free to download them, as well as some forms are downloadable basically to verify whether it's the qualifying exigency leave or the military caregiver leave. But qualifying exigency leave provisions, basically it's unpaid FMLA leave, but it's for different activities related to a family member being deployed. Short-term deployment or short notice deployment is when somebody hasn't been given months advance notice that they're going to be deployed. They're told, next week you're leaving for Djibouti, and that can cause a lot of chaos and disruption while you're the family is trying to take care of things, that means you can take up to 7 days of QEL leave to take care of those things. Military events and related activities are covered. If there are child care or school activities that have to be covered in preparation for the deployment, financial and legal arrangements, those you can take time off, up to 90 days after the termination of the uniform service. Counseling, R&R. Let's say a loved one is on a year-long deployment, but halfway through they get a brief R&R to come back to the States. The family member can take some time off from work to spend with them while they are here. Post-deployment activities are covered up to 90 days after termination. In terms of the certification and verification, again, I have some forms on the exhibit booth that are being provided. Feel free to download those. And then lastly, I want to discuss the military caregiver leave. And military caregiver leave will provide up to 26 work weeks unpaid leave during any 12-month period. It's a little bit different than the QEL leave. For one, obviously, there's more work weeks that are provided, 12 versus 26, but it is so it's determined on a rolling basis, where the 26 work weeks are rolling along, and depending on how much you've used over the 12-month period, you can use those. Now, one thing to keep in mind, you cannot use more than 26 work weeks in total combined with other types of FMLA. But it is on a rolling basis. So, depending on when you use the other types of FMLA leave, depends on how much you can use at any particular time. Another thing to keep in mind, it is per a covered service member. So if there may be multiple service members in a family, and maybe they both suffered injuries that would be covered, or maybe the same service member suffered one injury and then later on suffered another injury, and the parent or other caregiver had to take more time off, and that would be a separate 26 work week military caregiver allowance. So one thing to keep in mind, it does cover active duty. If the covered service member is an active duty service member, there's a different form. It does cover veterans, but it's limited to recently discharged veterans. And the standard is that the service member or the veteran must have used the first military caregiver leave within 5 years of being discharged. So we're not talking about veterans, pre 9/11, or depending on when they first use the military caregiver leave. It's not going to apply to veterans who have been discharged for a long period of time. Again, like I said, there are handouts on the Family Medical Leave Act, as well as the forms issued by the Department of Labor Wage and Hour Division by number on the exhibit booth. Please feel free to download them. And again, my apologies. I thought that the slideshow was being presented during my presentation. Hopefully you were able to gather the gist of what I was saying, or identify some of these issues. notwithstanding the fact that it did not display. But again, the PDF of the PowerPoint is contained on our exhibit. So please feel free to visit our booth and download what you would like. Actually, I'm going to see, hopefully if there are any questions before I sign off. I'm a few minutes ahead of the schedule here, but if there are any questions, I would be more than happy to address them. But again, I appreciate your time today and viewing this presentation. And please visit our booth and download any materials that you would like. One thing I do recommend, especially dealing with ESGR and USERRA, and you're an employer, there's an employer resource guide on the exhibit, which is very informative, has a lot of material there for you. And I encourage you to download that and review that. Otherwise, there are some fact sheets dealing with different things. One of those that I would again like to highlight. Now that I know that this presentation has been marketed towards employers. I don't know if there might be some service members on here as well, but one fact sheet that we have, a recent one, deals with employer requests. And those are requests that employers can make of each ESGR and or the unit, and how to do that, and what the guidelines are, and the information that you can obtain, whether it is about the type of discharge, the amount of service that a service member has had, whether they've exceeded that 5-year cumulative service that I mentioned, and how to proceed with having orders changed if you are in a situation where your service member employee is the key employee, during a certain period of the year. For instance, tax preparation season, you can obtain some adjustment of those orders by the command unit. So again, if you have any questions, I'm more than willing to answer them. Otherwise, I will sign off here, but I will be at the ESGR booth. I do encourage you to stop by and check out our resource materials. And again, please download the PDF of the PowerPoint presentation for your own reference. And I thank you, and have a good day.